Hello friends, I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's discussion is meaning, nature and functions of law. Welcome all to today's talk. Dear friends, after going through today's module, you will be able to understand the concept and meaning of law, nature of law and functions of the law. Dear learners, the present module is divided into 4 parts. In the first part of this module, we will discuss the meaning and definition of law. The second part of this module talks about the nature of law as a social and normative science. Law is dynamic in nature and law is territorial in nature. In the third part of this module, we will discuss the jurisprudential aspect of nature of law. And in the fourth part of this module, I will put light upon the general functions of law and functions according to different jurists of the jurisprudence. So friends, we will begin with the brief overview of the module. Have you ever felt the necessity of law in your day-to-day life? Have you seen anyone being booked by the traffic police for violating traffic rules? Do you feel the necessity of a birth certificate when a child is born? After the death, do you know the importance of a death certificate? The law affects all aspects of our life. It rules us from cradle to grave. It protects us from right to mother's womb to our education, service, marriage and other important events of the life. Law plays an important role in our daily life, right from buying a newspaper or a bottle of milk or any other big or small item necessary for our life. Law is so important in our lives that it becomes essential to understand various aspects of law as what are the sources of law, what are the kinds of law, and finally its application for the best use of our society. Law is a vast subject that is constantly changing and evolving. It may look easy to study and work with, but it takes years to be able to gain expertise in this field as one never stops learning about law. Laws have been around since ancient times and are considered the building blocks of a society. Plainly stated, a law is a rule or set of rules that are set up by an authority or the society itself and are applied to a community or territory. However, no single definition of law can fully express its meaning universally, as law itself is a dynamic. The term law denotes different kinds of rules and principles. Law is an instrument that regulates human conduct, behavior. Law means justice, morality, reason, order and righteousness from the viewpoint of society. Law means statutes, acts, rules, regulations, orders and ordinances from the point of view of the legislature. Law means rule of court, decrees, judgments, orders of courts and injunctions from the point of view of judges. Therefore, law is a broader term that includes acts, statutes, rules, regulations, orders, ordinances, justice, morality, reason, righteous, rules of courts, decrees, judgment, orders of courts, injunctions, tort, jurisprudence, legal theory, etc. Friends, now I would like to discuss the meaning of law. The term law has different meanings in different places, societies at different times, as it is the subject of amendments. In the Hindu religion, law implies dharma. In Islam, it is hukam. In Roman, it is jus. In French, it is droit. In Arabic, al-Qanun. In Persian and Turkish, it is qanun. In Latin, it's legum. In Filipino, it's betas. In the Albanian language, it is legs. In Czech, it's zakun. In Danish, it's lur. In Dutch, it is wet. So, the law differs from religion to religion in sense of personal laws. For example, Hindu law, Muslim law, etc. For instance, in India, a Muslim man can have 4 wives living at a time, but a Hindu male can have only 1 wife living at a time. If a Hindu male marries again during the lifetime of his first wife, he is declared guilty of the offence of bigamy and is punished under section 81 of the Bharatiya Nyaya Sanhita 2023. The law is a subject to change with the change in society and also change in government, legislative through the amendments and acts. So friends, following 3 things are often meant by the term law. The first one is, law signifies the concept of a legal order. This refers to structured system that governs relationships and directs proper conduct through an organized and authoritative influence of a political society. It establishes a framework for resolving conflicts and maintaining order by employing the regulated force of the governing body. Law means the whole body of legal precepts which exist in a politically organized society. The second one is, law is used to mean all official control in a politically organized society. This led to the actual administration of justice as contrasted with the authoritative material for the guidance of judicial action. The third one is, the term law extends to encompass all forms of official control operating within a political structured society. This encompasses not only the theoretical constructs of law, but also the practical application of justice. It involves the implementation of established legal principles to resolve disputes and uphold fairness in society. This aspect of law distinguishes between the theoretical guidance provided by legal frameworks and the active execution of justice by authorities. Dear friends, further we will discuss definition of law. Although there is no general definition of law that includes all the aspects of law, yet for a general understanding, some of the important definitions are as follows. The first one is by Aristotle. According to Aristotle, it is inherent like man and woman and can be discovered through reason. It is immutable, universal and capable of growth. According to Austin, law is the command of sovereign, rules laid down by political superiors to political inferiors. In other words, body of command by a sovereign member or members of any independent society wherein the author of the law is supreme. According to Patton, law consists of a body of rules which are seen to operate as binding rules in the community, using which sufficient compliance with the rules may be secured to enable the set of rules to be seen as binding. According to Salmond, law is a body of principles recognized and applied by the state in the administration of justice. That is, principles recognized and applied by the state in the administration of justice. The next one is Roscoe-Pont. According to Roscoe-Pont, law is a social control through the systematic application of force in a politically organized society, an instrument to satisfy the maximum wants in a society with the minimum of friction and waste. Dear learners, after going through the meaning and definition, it is pertinent to know the purpose of the law. The purpose of the law is to establish societal order by setting standards, guiding behavior and resolving disputes. The law safeguards individual rights and freedoms, ensuring fairness and justice. It acts as a framework for maintaining harmony, regulating conduct and offering avenues for conflict resolution. Additionally, law adapts to societal changes, serving to achieve social justice. The function of law extends beyond a mere set of rules, actively contributing to the well-being and stability of communities and individuals. So friends, the next part of this module is nature of law. Let us have a look. From a different meanings of law, its nature can be derived as follows. Law is a social and a normative science. The essential point of law is to manage human need. It has been invented to keep control in the society. Accordingly, the law is a social science and is regularizing in nature since it sets down rules for human conduct. This view emphasizes that law is deeply intertwined with societal structures, behaviors, and norms. Law is seen as a reflection of societal values and a tool for social regulation. Law as a normative science focuses on law's role in prescribing norms and standards for behavior. It suggests that law is concerned with what ought to be rather than what it is. It involves the study of principles, rules, and standards that govern conduct and the evaluation of these norms from moral, ethical, and logical viewpoints. Roscoe Pond, a prominent legal scholar, contributed significantly to the understanding of law as a social science. His theory of sociological jurisprudence emphasized the role of law in addressing social needs and its adaptation to societal changes. For instance, Keshwananda Bharti versus State of Kerala is a landmark case where the Supreme Court of India discussed the relationship between law and society, emphasizing the need for legal principles to adapt to changing societal values. Philosophers like H.L.A. Hart and John Rawls have discussed law from a normative perspective. Hart's work on the concept of law and Rawls' theory of justice as fairness illustrate how legal systems incorporate normative principles and the pursuit of justice. In short, we can say that law as a social and normative science captures its dual role as a reflection of and influence on societal norms and as a framework for prescribing and evaluating normative standards of behavior. Dear friends, next is law is dynamic in nature. A fundamental component of law is its dynamic nature. In case of K.K. Verma versus Union of India, the Supreme Court of India stated that most noteworthy prudence of law is its adaptability and flexibility. Law is dynamic emphasizes the idea that legal systems are dynamic and develop in reaction to shifts in society, technology, and moral principles. Laws frequently undergo reforms to address emerging issues, rectify injustices, or adapt to societal changes. For instance, the Indian legal system has seen numerous amendments in areas like family law, criminal law, and environmental regulations to keep pace with the societal developments. The Indian Home Ministry recently announced the enactments of 3 new criminal laws: Bharatiya Nagrik Suraksha Sanhita 2023, Bharatiya Nyay Sanhita 2023, and Bharatiya Sakshya Adhiniyam 2023, with effect from 1st July 2024. These new laws repeal the British-era Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872 respectively. The new laws overhaul the Indian criminal justice system. They aim to revamp and replace the dated colonial laws by considering the implementation of justice through a victim-centric approach, increasing focus on national security and introducing digital electronic evidence reviews, making them priorities of these laws. Judicial activism refers to the practice of courts actively influencing laws and policies, particularly in areas where legislative action is insufficient or delayed. In instances like Keshwananda Bharati versus State of Kerala, the Supreme Court of India became well known for its strong stance that created the doctrine of basic structure, which ensured that original spirit of the constitution could not be altered by constitutional amendments. The law must adapt to technological advancements. Issues like digital privacy, cybercrime, and intellectual property rights have prompted new legal frameworks. For example, the introduction of the Information Technology Act of 2000 in India was a direct response to the rise of digital technologies. Legal systems evolved to reflect changing social attitudes and norms. For instance, the decriminalization of same-sex relations in Navtej Singh Johar versus Union of India illustrates how legal reforms can align with contemporary views on human rights and social justice. The dynamic nature of law reflects its responsiveness to the evolving needs and values of society. Through reforms, judicial interpretation, and adaptation to technological and social changes, the law remains a living, evolving system that seeks to address contemporary issues and reflect societal values. The further one is, law is territorial. Dear friends, the requirement of law is restricted to the domain of a state. Various states throughout the planet have their own overall sets of laws. A demonstration that is a wrongdoing in a state A may be viewed as a righteous in a state B. A current general set of laws has presented the idea of extra-regional law, whereby certain laws might be implemented outside the territory of the state. The idea of extraterritorial laws has been perceived by the Indian legal system too. Dear friends, now I would like to put a light upon jurisprudential aspect of nature of law. The jurisprudential aspect of the nature of law encompasses various theories and concepts that philosophers, legal scholars, and jurists use to understand and interpret the nature, purpose, and application of law. Here are some key jurisprudential perspectives on the nature of law. The first one is analytical school of jurisprudence. According to this school, law is a set of rules created and enforced by the state or governing bodies, or its validity is not depend on moral consideration. Jeremy Bentham, John Austin, and H.L.A. Hart are the main jurists of this theory. Legal positivists emphasizes that law is a matter of social facts and institutions rather than moral values. They argue that laws are valid if they are created through recognized procedures regardless of their content. The second one is natural law school of jurisprudence. Thomas Aquinas, John Finnis, and Hugo Grotius are the main supporters of this theory. According to them, law is based on inherent moral principles that are universal and can be discovered through reason. Natural law theorists argue that there is a higher moral order that laws should reflect. If a law is unjust or does not align with moral principles, it is not considered valid. The third one is historical school of jurisprudence. Dear friends, the historical school of law emphasizes the evolution and development of law as a reflection of the historical and cultural context in which it arises. This school of thought is closely associated with the work of German jurists in the 19th century, notably Friedrich Karl von Savigny. According to this school, law often originates from customary practices and traditional norms that have developed within a community over times. These customs are seen as the basis for legal rules and institutions. Legal rules and principles are viewed as expression of the cultural and social life of people. They reflect the values, beliefs, and practices that have evolved historically. Dear friends, the next one is Sociological School of Jurisprudence. Roscoe Pont and Emil Durkheim are the main supporters of this school. Sociological jurisprudence focuses on the social function of law and its role in maintaining social order. It examines how laws reflect and influence social values and structures. Law must be understood in its social context, considering how it affects and is affected by society. And last one is Realistic School of Jurisprudence. According to the approach of this school, law is not just a set of abstract rules, but is shaped by how it is applied and interpreted in practice. Oliver Wendell Holmes and Carl Lavalin are jurists of this school. Legal realists focus on the behavior of legal actors like judges and lawyers and the practical effects of laws. They argue that understanding law requires examining its real-world application rather than just its theoretical content. Dear students, in the last part of this module, we will discuss the function of law. The functions of law have been subject of diverse perspectives among jurists. Law is recognized as a dynamic concept that evolves with time and location, adapting to societal changes. Its contemporary interpretation positions law not merely as an end but as a means to achieve an end, the attainment of social justice. The consensus among theorists is that laws serve as a key instrument for ensuring justice. One viewpoint articulated by Holland on functions of law asserts that law serves the greater welfare of society, transcending its role as a mere safeguard for individual rights. On the other hand, Roscoe Pont identified 4 key functions of law: the preservation of law and order, upholding of societal equilibrium, the facilitation of individuals' freedom, and the satisfaction of the fundamental human needs. He perceived law as a form of social engineering, constructed to optimize the welfare of both individual and the state. One viewpoint articulated by realist jurists that function of law in jurisprudence advance the best interest of individuals and the state, acting as a regulatory force. Therefore, law serves several critical functions in society, helping to maintain order, resolve disputes, and promote justice. Overview of the key functions of law. The first one is to deliver justice. Delivering justice through the law means ensuring that everyone is treated fairly and equitably. It involves holding individuals and institutions accountable for their action and ensuring they face appropriate consequences. Justice means that no one, regardless of their status or power, is exempt from the law. It requires upholding the rights of individuals and giving them a fair opportunity to present their case. Justice is not just about punishment. It also involves restoring balance and addressing the harm caused by wrongdoing. It is about giving a voice to victims and addressing their grievances. Further, to provide equality and uniformity. Ensuring equality and uniformity through the law means that everyone gets treated fairly, no matter their background or status. It's about making sure that rules apply equally to everyone, without any exceptions. Whether someone is rich or poor, powerful or not, they should be subject to the same laws. By promoting equality and uniformity, the law builds trust in a system and fosters a sense of fairness and justice in society. It ensures that nobody gets special treatment based on things like wealth or influence, making the community more inclusive and united. Moving further, to maintain law and order. Maintaining law and order means ensuring that society remains peaceful and orderly. It involves enforcing laws and regulations to make sure people follow the rules and respect others' rights and safety. Law enforcement agencies play a critical role in this by patrolling communities, investigating crimes, and arresting those who break the law. The legal system also provides a framework for resolving disputes and holding individuals accountable for their action through fair and impartial justice processes. When law and order are maintained, society can function smoothly and people can feel safe and secure in their homes and communities. It builds trust and stability, allowing everyone to go about their daily lives without fear of violence or chaos. Further, to maintain social control. Maintaining social control involves setting and enforcing rules within a society to guide people's behavior and prevent disorder. This includes using various methods such as laws, customs, and informal social pressures to encourage individuals to follow accepted standards of conduct. It also helps to prevent and address behaviors that go against these norms, ensuring that the community can function smoothly. Ultimately, social control is crucial for preserving social cohesion, building a sense of belonging and respect among members, and maintaining peace and stability in society. So, friends, now I would like to conclude my talk by saying that law is essential for ensuring justice, maintaining order, and promoting equality in society. It provides a framework for resolving conflicts, ensuring fairness, and driving social reform. By upholding principle of fairness and accountability, law builds trust in institutions and fosters unity within communities. Through orderly change and adherence to legal norms, societies can address challenges and work towards a more just and equitable future. Therefore, the significance of law cannot be overstated in safeguarding the well-being and stability of individuals and society as a whole. So, with this, we will end today's talk. Thank you so much. We will see you in the next video.